Good morning and welcome to today's webinar, Trustee Selection and How to Choose the Right One for You. Presented by Elville & Associates Managing Principal and Lead Attorney, Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. This is our quarterly presentation, so welcome to everybody. We encourage your general questions anytime, so please note them in the questions panel on your screen, and we'll take time throughout to address them. More case-specific and personal questions may be best discussed in a consultation with Steve, but your questions really help the presentation and add value. They always help others learn, so please don't be shy in posing your questions at any time. You received the presentation slides yesterday by email from me to take notes on them if you wish, and the presentation is also available in the section marked Handouts in the panel on your screen to download at this time. Welcome to our professionals on today's presentation as well. For CFPs, CPAs, and most other professionals, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements on my end, if applicable, please email me your ID number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey and offer us your thoughts and comments about today's presentation, and we always read and value every comment that you have to share with us. Here at Elville & Associates, we want to be a resource to you for your families and your planning needs now and in the future, so consider a consultation or a document review with Steve after today's presentation. Use today's education as a jumping off point to get your planning started. Consultations are a great and the most ideal way to get your questions answered, have Steve understand your individual situation, and help create solutions and a path forward for you. So before we get started, I'd like to give Steve and the firm a proper introduction. We're going to do a brief poll to learn what brought you here today, and then we'll jump into the presentation. So, I'll share my screen briefly here. Elville & Associates, we were founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we offer here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates. We do that in several ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities we serve each year through all of our attorneys here at the firm, and also by way of our accredited client care program. We're one of only 2 firms in Maryland to have an accredited client care program, or CCP as we call it, accredited by the Client Care Academy in Boston. And we also work each day with the ideals of client education, collaboration, and compassion in mind every day here at Elville & Associates. Also a little bit about Steve. His work as an attorney for the past 20 plus years, I think 23 to be exact, has been centered in elder law, special needs planning, and estate planning, with an emphasis in the areas of tax planning and asset protection. A member of many different national membership organizations, he works to bring peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker. If you haven't heard Steve present before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization that he founded in 2014, and I am very privileged to be the executive director of. So if you'd like to learn what we do at the Elville Center and how we work each day to make a musical difference in the lives of children, please feel free to reach out to me, and I would love to share our story with you. We have a lot to share, but right now we don't have time for that. We're going to talk about trustee selection, which is a very, very important topic in estate planning. And we're going to do one more thing before we do that. we're going to start a poll. And the poll is, what has brought you to today's webinar? Please select the response that applies to your current situation. So I'm going to launch this. And your choices are: 1, I'm a grantor, I've established a trust before. 2, I've been or am a trustee of a trust. 3, I am the beneficiary of a trust. 4, I'm considering establishing a trust. Or lastly, I'm an advisor here to learn to better serve my clients. So you may fit a few of those situations, but maybe choose the one that best suits your specific situation right now. Hope everybody has some good plans for Memorial Day weekend, otherwise known as Jeff's birthday weekend. Going to be 25 again for the 23rd straight year.
Jeff, you've been holding out on us now. Tell us the day.
Still feeling pretty good. Okay, give it another few seconds here. All right, so we have 25% of the attendees saying, I'm a grantor, I've established a trust before. 12% say I've been or am a trustee of a trust. Nobody says I'm the beneficiary of a trust. 49% say I'm considering establishing a trust. And 14% say I'm an advisor here to learn to better serve my clients, which is always great to see. Welcome to everybody. Steve, I'm going to go ahead and make you the presenter.
Thank you, Jeff.
Close out this poll first.
All righty.
Make you the presenter.
All right. Thank you so much for that wonderful introduction, Jeff. I'm going to get my screen up here and get my slideshow going. And good morning, everyone. And thank you again, Jeff, for that wonderful introduction. Thank you for spending your valuable Friday morning with us here on this webinar. And I welcome you on this special long Memorial Holiday weekend getting ready to start. And I hope everyone has a wonderful weekend ahead and planned. And it's my great privilege to be with you. And without Jeff and without all the associates and staff at Elville and Associates, I wouldn't be able to do what I do. And we wouldn't be able to do what we do without you. So thank you for supporting our webinar series. And for all of those who have attended before, thank you for coming back. And for all of you who may be new to our webinar series, thank you for coming. So today, my job is to lead you through a discussion and to give you a set of tools about how to choose trustees. Now, I want to lay the groundwork for this a little bit. And basically, this is a mini masterclass. And I know that word is used a lot today, but I have no other way of really describing this. This is a way for you to kind of get your mind around this whole topic. And it will give you a way to think through the issues. But at some point in this presentation, you're going to ask yourself, why am I kind of deviating from the actual discussion of trustee selection itself? And I'm kind of going into a mode of giving you some groundwork, some framework, some education about trusts in general, because I don't see how you can properly choose trustees unless you understand what their responsibilities are, what you're expecting from them, and what beneficiaries can expect from them. So I'm going to be spending a lot of time kind of going around the edges so that we can think about the trustee selection. And nothing could be more important in this day and time. One of the main questions we get in our conference rooms at Elville and Associates and at webinars and presentations outside of our office is really, how do I think in terms of trustee selection? So you're at the right place at the right time to start thinking through this. And remember that it's sometimes a process. Sometimes it's a series of meetings that are designed to help you think through certain things and have epiphanies that may come about who should be the trustee and the different types and so forth. So with all of that said, make notes and use your tablet and feel free to ask questions. This is a rather informal presentation, as many of our presentations are. Jeff is an expert moderator. We will take breaks from time to time to see if there's any questions. But if something strikes you as something that you really need to ask a question about, remember that it adds to the benefit of the discussion for everyone, and don't be afraid to ask those questions. So with all of that said, as we gear up for the Memorial Day holiday weekend, let's now take about an hour and 15 minutes and really focus on trustee selection and how to think in terms of that for yourself and for your family. So of course, the things I talk about today can't be construed as legal advice because we don't have an attorney-client relationship over this webinar, but what it is at a very high level are concepts that hopefully you can use as tools, and then eventually we could discuss those things as needed in an attorney-client relationship. All right, what will we discuss today? Well, what is a trustee exactly? And as we think through how to choose one, what is the trustee and what are their responsibilities? What are the types of trustees and their characteristics? And although we can't cover everything in an hour and 15 minutes, we're going to talk about advantages and disadvantages of certain trustees. And of course, every client situation is different. So what we might say here from a certain point of view might be different from an actual set of circumstances about a certain point of view that you may have. What is the perfect trustee? We want to set a benchmark for selecting trustees. We want to set that benchmark very high and hopefully attain that. Why is trustee selection so important? Now, we've said it's important, but really drilling down into why that is. And then trustee selection, excuse me, trustee selection in the plan process. Why is this so difficult and how can we make this more viable? And I'm going to argue that we can make the trustee selection process much more viable through a process, through a logical process of plan design. What are trustee roles in wills and trusts? And we're going to find out that certain wills and certain trusts are similar, but there are also different kinds of trusts, testamentary trusts and lifetime trusts. And trustee roles might be slightly different, but similar in those situations. And why would some people consider appointing a corporate trustee, like a bank or a trust company? And then I want to talk about briefly what is trustee risk. What is the risk when we have successor trustees down the line, which is one of the biggest things that people are concerned about today? What is that risk that we should try to do as much as we possibly can about? Okay, let's talk about what is a trustee and what are their responsibilities. So some of this is intuitive. Some of this you're going to say, Steve, I knew that, I know that. But I'm going to talk to you in terms of perhaps you don't know really anything about this, or you might have some misconceptions. And there may be people on the webinar today that know nothing about this particular thing. So I'm going to talk to you in those terms, very simple terms, and let's just go through it. So the role of a trustee is to actually administer a trust. A trust, as we're going to find out, is more or less a contract. It's kind of a private agreement, and it has terms and provisions. And the trustee's role is actually to follow those terms and provisions and to keep accurate records and so forth. Now, I'm going to stop very briefly, and I'm going to be redundant intentionally about some of these things so we can learn. How many of you would believe it if I told you that many trustees do not even read the trusts? Well, it's true. I hate to say. So I don't know what it is, whether it's life or whether it's inertia or whether it's a lack of focus or whether a lot of trustees are overwhelmed with the duties and they just don't look at the trust too much. But we want our trustee to actually read the terms and provisions of the trust, if nothing else. So that's a really important thing. It's fundamental, but just realize many trustees do not actually scrutinize and read the terms and provisions of the trust. And of course, as I just mentioned, they have to keep accurate records. They have to account to the beneficiary. Now, one of the trustee's major duties is to account. If you were to say to me, Steve, what is your opinion about this particular situation involving a trustee? One of the first things I would say is, well, let me see a recent accounting. And is the trustee accounting on an annual basis? And this is something that is somewhat loosey-goosey in today's world, in my opinion. But we want as a best practice to know that a trustee should account. The trustee needs to make distributions according to the terms of the trust for the benefit of the beneficiary. Now, these distributions could be mandatory. The trustee shall distribute out income. The trustee shall distribute out principal. Or these things could be discretionary. The trustee may distribute income. The trustee may distribute principal in their absolute discretion and so forth. The trustee has to make trust investments. So one of the fiduciary duties, so that's the first time I've used that word. The trustee is a fiduciary. They have fiduciary responsibility, and they must carry out that fiduciary responsibility, or they could be removed or be deemed to breach their fiduciary duty. So they need to make investments. They need to hire professionals. There are trustees who make their own investments. They are non-professionals and they make their own investments. We do not recommend that. I'm not saying it couldn't be done, but by and large, a trustee has the ability to hire professionals, and they really should do that. And we're going to talk more about that. The trustee needs to communicate with the beneficiaries. Beneficiaries in this day and time are entitled to notice. We're talking about Maryland law now. This is Maryland law that beneficiaries are entitled to notice, qualified beneficiaries, and they're entitled to information, and they're entitled to communication from the trustee. So it would be a breach of duty for the trustee not to communicate. The trustee has tax compliance obligations. They have to make sure the trust tax returns are filed. So most trusts will file a tax return called a 1041, which is a fiduciary income tax return. It's not always required, but it's something that is a best practice in many instances. And the trustee has to manage the assets, taking into consideration that income taxation of trusts, which is a complex subject, has its own nuances. So the trustee cannot be blind to this. They have to understand that not only are there obligations to do tax compliance and filings, but how they manage the trust assets could determine how the investments should be made with relation to the tax filings and the income taxation of the trust. So that's a very complicated thing that I just brought up. I'll try to bring some clarity to it if we have time before the end of the presentation. So let's go over some basic definitions now and very, very basics of trusts. And remember, so far, we talked a little bit about trustee selection. We talked about some of the parameters, but I'm laying the groundwork for your understanding of how to really think clearly through this. And I know it's very fundamental, so thank you for working through this with me. So what is a trust? Well, a trust is a relationship. I said it was kind of a contractual agreement. It's a relationship between the parties. Now, in today's world, we call the person creating a trust a grantor. In the old days, this might be a donor or a trustor, and these were the terms of art that were used. But now the modern term is grantor. So the person creates a trust, the grantor, for the benefit of a beneficiary, and the trustee is the person who follows the parameters and responsibilities of the trust provisions and applies those. So who are the parties? Well, the grantor, we just talked about this, the person that generally establishes the trust and funds the trust. The trustee is the person or an entity like a corporation that accepts the property. They actually have to sign something that says, I accept the trust property, especially a successor trustee who takes over. They say, I'm going to accept this, I sign for it, and I promise to manage this property for the benefit of the beneficiary, as directed by the grantor, not in the discretion of the trustee unless the trust says that, which many times it does, but we're going to talk about more about what a grantor can do to make sure that the trust is clearly understood as to the grantor's intentions. And of course, the beneficiary is a person or persons that the trust is intended to benefit. So how the distributions are made, when are they made, and for what purpose are they made? These are things that have to be interpreted by the trustee when they read the trust document. So let's just drill down for a second here. If you're making notes, I would make notes on this. How many of you have heard of something called an ascertainable standard? Well, whether you've heard that or not, you've probably seen it. You've probably seen somewhere in your life, perhaps a trust that said, the trustee should distribute this trust for the health, education, maintenance, and support. Health, education, maintenance, and support, HEMS. That is an ascertainable standard set forth by the IRS in the world of trusts and estates. Now, that's very broad if you think about that. My trustee may distribute in their sole and absolute discretion for the health, education, maintenance, and support of a beneficiary. Very broad. What does that actually mean? Well, if you were to attend the highest estate planning conferences in the land, you would find out that even the best of the lawyers still don't really understand what that means fully. Now, I'm not saying they don't have an intellectual understanding of what it means, but they don't necessarily have the understanding of what the grantor means by that. So going back to that second bullet point here, when we have a trustee managing property for the benefit of our beneficiaries, and we simply say to them, distribute for health, education, maintenance, and support, what do we really mean? So the thing I would like you to write down, just as a bullet point for today, giving you as many tools as I possibly can, is to have a letter of wishes. A letter of wishes. This is something that we're happy to provide to you if you would like to know what it is. And you can use this as an informal attachment to the back of any will or trust where there is a trust for a beneficiary involved. And you can elaborate on your goals and values and your aspirations and intentions for the beneficiary. And does this give guidance to the trustee? Absolutely. So as you think through trustee selection, we also want to be thinking through trustee direction. So not just selection, but direction. Now, a revocable trust, many of you on this webinar today may have one of these. This is what? Well, it's a substitute for a will. A revocable trust is nothing more than a substitute for a will. In basic estate planning, we have wills or revocable living trust, which is a substitute for a will. And in a very simple way, I would say it's a fancy will, but that's an inaccurate definition. It's actually a substitute for a will, and it can be modified, amended, or even revoked, and it's taxed as if it doesn't even exist, meaning Uncle Sam looks straight through the revocable trust, straight to the grantor, and says, you know what? Your tax ID number is used for this trust, your social security number. We're going to act Uncle Sam is going to act as if this trust doesn't even exist. Now, an irrevocable trust is a trust that may not be amended. However, I want you to put a big star beside that. There are ways to amend an irrevocable trust. And as some of you probably are taking a sip of coffee and shaking your head, I would not blame you. An irrevocable trust can be amended, as counterintuitive as that may seem. And in some cases, it's a very good idea that these trusts have the flexibility to be amended. But as we think about these irrevocable trusts, these trusts can be what? They can be trusts at death. If this is our date of death, we are leaving further trusts for beneficiaries, a spouse, children, grandchildren, nieces and nephews, or others. It could be a lifetime trust, not just a trust at death. It could be a lifetime trust like a life insurance trust or a special needs trust or a charitable trust. These are irrevocable trusts that we create during life and not necessarily at death. So these trusts are either going to be taxed as grantor trusts, just like a revocable trust. The trust is ignored and the grantor pays the income tax. That's a grantor trust. And a non-grantor trust, a good example of that would be I pass away and leave a trust for my child. That is going to be a non-grantor trust, an irrevocable trust at my death. So these trusts generally have a tax ID number, but It does not matter whether they have a tax ID number or not. They are still going to be considered taxable to the grantor if it is a grantor trust. So again, you're going to be sent the link for this webinar today. If you need to hear this again, you'll be able to listen to it again. And if you don't get this at the first pass, do not beat yourself up. It takes years and sometimes months at least to get your mind around some of these legal and tax concepts. So a traditional revocable trust, what does it do? Well, it doesn't do anything fancy, to be honest with you. It avoids probate. It can be a nice tool for certain family situations. It provides privacy. It can be a cost-saving measure for administration, and especially if you have out-of-state property. So if you're a person that says, well, I live in Maryland or the central area of the Atlantic, but I have another property down in Florida or over in Delaware or in Virginia or West Virginia, this says I can put that property, which is residential, inside my revocable trust, and I can avoid probate in my home state, Maryland, let's say, and in the ancillary state. Now, the disadvantages of a revocable trust, in my opinion, are very few, but there are sometimes people who are uncomfortable funding their assets into a revocable trust. So we have to have a trust that is actually created properly, and then we have to transfer our assets to it. So when we think about trustee selection, we want to think about the type of trust. That's what this is all about in these last couple of slides. Now, we have trusts for at-risk beneficiaries. Maybe there is a beneficiary who is a minor. This is one of the most common trusts. If I'm a parent and I pass away and my child is a minor, I'm going to leave a trust at my death for that person. The trustee uses this property for the best interest of the person. Or this could be a trust that lasts forever, a dynasty trust, or what we might call a bloodline trust, a trust that goes down your family generations and is intended to stay in the family until there's no more money. So these are the common types of trusts that are implemented today, just a few of them. More common trusts. These are trusts similar to what I just described that tend to last for a long time. We die and we say, well, we're not just protecting our beneficiaries on a temporary basis until they are a certain age. We are benefiting our beneficiaries as far as asset protection, protection against divorce, protection against car accidents and bankruptcy. We're just going to leave this money in trust forever for that beneficiary. So that beneficiary can actually be the trustee in Maryland and be the beneficiary. In some states, that is not allowed. So just setting the stage for how to think in terms of trustee selection. Here we have a situation in this bullet point where a child or other beneficiary has been given a trust at death. This trust could also be during life, actually, but many times is at death. This is for asset protection, but the child could actually be the trustee of their own trust. And one of the counseling issues is whether this is a good idea. So as you think about trustee selection, should a successor trustee of my revocable trust or any other trust be my child? Should it be a child, meaning a sibling, or maybe even a non-family member, an independent person, or should it be a corporate trustee? And if we do name a child as trustee of their own trust, what are the pros and cons of that? Well, it's beyond the scope of today's discussion to some degree, that particular idea, but we want an independent trustee if we can for the greatest asset protection. But some states like Maryland do allow what I will call a modicum, a measure of asset protection at least, if that beneficiary is the trustee of their own trust. So there's a pro and con to that, and that's a counseling issue. Now, of course, there are special needs or what we call discretionary trusts under the law, and these trusts are designed to protect at-risk beneficiaries who are disabled, who may have intellectual disabilities or other disabilities, and these are designed to protect that beneficiary, protect their assets from being considered available resources for public benefit purposes. So the thrust of these types of trust is to provide a safety net and a world of support above and beyond public benefits, but also to protect the beneficiary from fraud, abuse, and the claims of creditors and so forth. All right, so we're setting the stage for the types of trusts: lifetime trusts, trusts at death, revocable trusts, irrevocable trusts, and how to start thinking within this hour and 15 minutes, how to start thinking in terms of better trustee selection. Now, again, being redundant, just make sure that we've got these concepts. The trustee is the person who is accepting the trust property and agrees to manage the trust property for the grantor, as directed by the grantor in the trust agreement, and as directed by the grantor in what? A further letter of wishes. A letter of wishes. So remember that. That would be a real advantage if you created a letter of wishes to help your trustee. Now, in the world of special needs, which we just mentioned, we might call that memorandum a letter of wishes, but we also could call it a memorandum of intent. We could create a memorandum that provides not just wishes, desires, and goals of the grantor, but provides personal information, medical history, doctors and their names and addresses, and family members, and many things that have to do with at-risk beneficiaries. And remember, the beneficiary is the person or persons for whom the trust property is intended to benefit. Now, we've spent a little bit of time talking about grantor versus non-grantor trusts. I'm not going to waste more time on that subject, except to say again, and to be intentionally redundant, the grantor trust is simply a trust where the grantor pays the tax. That trust could be a simple revocable trust, or it could be one of the lifetime trusts that is typically drafted as a grantor trust, such as a Medicaid trust or a life insurance trust. A non-grantor trust is a trust where the trust itself pays the tax. And I think at this particular bullet point or this particular slide, I'm going to just digress for maybe a couple of minutes talking about trust taxation. Jeff, do we have a question?
Thanks, Steve. Was going to mention that in just a moment. So we do have two questions. And the first one is, can a trustee be a beneficiary as well? If so, pros and cons?
Thank you for that question. And that's a great addition to the presentation. So thank you. It adds value. Well, conceivably, a trustee of a trust where there's more than one beneficiary, where that trustee is one of the beneficiaries, clearly that is a conflict of interest. So that's one of the first problems with that. Another example is where a related trustee is the trustee for another sibling. And that's just a recipe for disaster, although there's probably a 10% chance in some cases that that will actually work. But I think getting to your broader question, in my opinion, Maryland being one of the states that allows a trustee to be a beneficiary, I should say, to be the trustee of their own trust and still enjoy what I would call spendthrift protection. So let's talk about that. What is a spendthrift trust? Well, a spendthrift trust is an irrevocable trust. It's a trust created in something as common as your will or your revocable trust. And in that will or revocable trust, it contains a spendthrift provision. That spendthrift provision says what? My beneficiary who has a trust, that beneficiary does not have the authority to give away or assign their benefit of their trust to an outside party. And what that does is it creates a solid wall of protection around the money because the creditor cannot get in and the beneficiary is not allowed to assign out the trust property in satisfaction of a debt. So it is not assignable. So that spendthrift provision is very important. Now, when we say spendthrift protection, that's exactly what we mean. Maryland says we can have our cake and eat it too. We could let a child be the trustee of their own trust and still enjoy spendthrift protection. Now, in my opinion, there's more design that needs to go into a trust other than just a spendthrift clause. We have to think in terms of flexibility, a trust protector. We have to think in terms of what kind of power of appointment, if any, did we give the child? Because if we gave a child the power to appoint the property to whoever they want, we are probably opening up the trust to the claims of creditors potentially. So we probably want to stay away from that and use a limited power of appointment in some way. So all of these features are design features, but Maryland says that child can be the trustee of their own trust and enjoy this protection. So all of that long-winded explanation to say this: at a time of crisis, God forbid the child is being sued, the child has a divorce, the child a serious divorce going on, the child is filing bankruptcy, something terrible has happened in that child's life. Should they be, under those crisis conditions, should they be the trustee of their own trust when they might be dragged into court? They might be sued under the laws of a different state that does not follow Maryland law, and all of these things. And I think common sense would dictate that under those kinds of situations, the child should not be the trustee of their own trust. And in fact, from the get-go, it would have been better to have an independent trustee. But if we don't go that route and the child is the trustee of their own trust, we need to build in flexibility like a trust protector so that the child could be removed and replaced immediately with an independent trustee, which for various reasons greatly expands the asset protection of the child or whoever the beneficiary is. So that's a great question.
Thanks, Steve. We have one more that was just emailed to me, and it says, if a beneficiary of a revocable trust is to receive at death the balance of a particular bank account, is that beneficiary entitled to the entire trust document revealing what everyone else received?
Oh, that's a great question. That has to do with notice to qualified beneficiaries, and I think there's various opinions on that. And I think it's where and how that provision providing for that bank account is whether that's included in the trust. I think if you are a person who was very diligent in the drafting, and you specifically designated that, and it depends on where it was in the trust, that beneficiary may be entitled to notice, but certainly not to necessarily the other provisions of the trust. And so this is something that I think would have to be briefly analyzed. That's a great question.
Okay, thank you.
All right, thank you, Jeff. And I'm just checking my time. I think we're doing okay. So where we were, thank you for those questions, is we were talking about trust taxation. So I want to just spend a few moments. Remember, in a grantor trust, who pays the tax? The grantor. It doesn't matter how sophisticated a trust it may be. If it's a grantor trust, the grantor pays the income tax on any trust income. But if it's a non-grantor trust, the trust pays the tax. So for those of you who may wake up at 4 o'clock in the morning, hopefully not this Memorial Day weekend, and you may say to yourself, oh my gosh, what is going to happen here with trust taxation? Just trying to be humorous there. Here's the lay of the land on that. You and I, according to the Trump Tax Act of 2017, we would have to earn very, very high income, anywhere from $450,000 to $650,000. I don't have the numbers in front of me, depending on whether you're single or married, to be in a 37% tax bracket. That's the highest tax bracket. But a trust that is taxed on its own, a non-grantor trust, reaches the highest income tax at only around $14,500 of income. So we've got this problem of Uncle Sam compresses income taxation of trusts. Now, that means our trustee, as we think about trustee selection, they need to have a working knowledge of this. It's not that they can't overcome this, and it's not that they have to do it themselves, because a trustee can do what? And they should do what? Hire professionals. But the trustee does have to have a recognition and a working knowledge of the fact that if a trustee simply does not do what they're supposed to do, that non-grantor trust is going to pay too much income tax. It's going to be taxed at 37%. Now, what can a trustee do and what should they do? Well, when they have the Form 1041, the income tax return for trust, when they have that prepared each year, there's going to be this simultaneous analysis of how much income was distributed out to who? The beneficiary. So we have the trust, it's going to be taxed at 37%. We also have a beneficiary who is in a certain individual income tax bracket. What's going to happen, to make a long story short, is the 1041 is going to tell us how much income did the trust have that's taxable. Now Uncle Sam simply says this: who is going to pay the income tax? Is it the trust or is it the beneficiary? And 9 times out of 10, we are going to want the beneficiary to pay the tax. Now, of course, some trusts are larger than others. Some trusts have more expenses than others, but generally speaking, the trustee is going to have passed out the income to the beneficiary during the year, or within 65 days of the new year, they're going to have that grace period to transfer out income to the beneficiary. And now what's going to happen? That income will be taxed on that beneficiary's own tax return, their own 1040, and the trust will not pay 37%. The only way 37% would still be paid is if the income of the beneficiary is very large. So if that were the case, then we would have to revisit the investments of the trust to try to lower the taxable income of the investments. So don't worry about the non-grantor trust income tax problem, because that's just something that has to be managed by the trustee and the CPA and financial advisor involved. Now, one of our wonderful questions just a moment ago was about who gets notice. So remember, as we think about trustees, we have to think about, are they going to do what they're supposed to do? I met with a person recently who's otherwise an excellent trustee. This is a person who does everything, but they did not know about the new requirement under the Maryland Trust Act that when they took over as a trustee, that certain notices have to be given to qualified beneficiaries. So we're not going to get into all of this, but there are notice requirements. So as you think about your trustee, you want to make sure that they are the kinds of persons or organizations that understand these notice requirements, because a trustee not only has to do this for the benefit of the beneficiary, but they could be removed as breaching their fiduciary duty, because we know not all beneficiaries are warm and fuzzy and friendly with trustees. So we have to be aware that our trustees have these fiduciary duties, and they cannot ignore them or not be aware of them. And so that's why I commend you today for being on this webinar, and you're educating yourself and you're also educating your potential trustees. With that said, I want to say that in any planning situation or in any update situation where documents are being reviewed, and even old documents, old trust documents certainly should be reviewed if they are existing, because whether they're revocable or irrevocable, there are going to be ways to be able to probably change those documents, update them, modernize them as needed. You'll notice that at the very bottom here, it says that in Maryland, a quiet trust, a trust where no one gets notice, no one gets information, in Maryland, in my opinion, is not possible. There is a provision of the 2014 Maryland Trust Act that seems to indicate that we could have a quiet trust where a beneficiary that we certainly don't want them to have any notice, that somehow we can keep them from getting information about the trust. But I think some of the brightest minds have thought about this, and I've certainly looked at it, and I don't see any way around them not being able to get access to information beyond the scope of this discussion today, but just something that you should be aware of. Beneficiaries in Maryland are entitled to notice, and they are entitled to information. And what information are they allowed to get? Well, a copy of the trust agreement, annual reports, trustee termination or appointment. And as the person who asked the wonderful question asked, is everyone entitled to this if they are only a beneficiary of a bank account or a specific provision in the will or trust? This is going to be a case-by-case situation that has to be analyzed, because remember, if the trustee doesn't follow their fiduciary duty, they could be removed. Now, what is the role of a financial advisor in establishing a new trust? As you think about who is my trustee, who is going to do these things, who is going to follow best practices, who is the best person or organization that I could appoint to follow these guidelines and actually take care of my loved ones, whoever they may be, or whatever that purpose of that trust is. And I know we have financial advisor friends and possibly new financial advisor friends on this call and webinar this morning. So you know, and CPAs on the call know, what an important role you play. But we're talking about financial advisors here. So your trustee, in my opinion, remember, should not be making investments themselves unless they are a professional investment advisor. So the trustee should hire professionals. Now, what should they do? Well, they should work closely with that professional, because that professional is going to do what? Give that trustee, and write this down, an investment policy statement. Mr. or Mrs. Financial Advisor, I am a new trustee, and I'm talking about individual trustees here, and I've got a duty, I've got a fiduciary duty to take care of this beneficiary, and I am going to invest according to what? I need to invest according to fiduciary standards. I need to act as a prudent person would, and I need you to assure me that you're going to do the same, and get something in writing from the financial advisory firm that's called an investment policy statement. And a good financial advisor, which I'm thinking of one now right off the top of my head, who is just unbelievable about getting back to me every year, making sure that I am going through, I'm thinking of several actually, who are excellent. And they say to me, Steve, it's time to review the trust. It's been a year, and sometimes we review in between. This is the investment allocation. This is what we're doing. Looking at the tax ramifications, looking at the markets, which I'm not an expert at, and talking about how the accounts should be set up if we're setting up a new trust. The trustee has to get a tax ID number for the new trust. So we're working with the financial advisory team very closely, and your trustee should be doing the same, and they should be open to it. If you have a potential trustee who says, well, I'm just going to make the investments myself, I'll keep my own accountings, and I don't know if I'm ever going to actually give someone an accounting, this is a very, very bad, and we want to stay away from such a thing. I have seen beneficiaries not receive an accounting from a trustee for years. I have seen trustees who are otherwise very, very wonderful people never provide an accounting for 8 or 10 years, and they're putting themselves at risk. But I'm digressing a little bit here from the financial advisor slide, and I'm just trying to say our trustees need to be very high-level people and work with professionals. Now, of course, as I just mentioned, the financial advisor manages the trust portfolio and is going to advise about the allocation. One of our wonderful financial advisor groups or friends helped us in a situation in the last several years where a very self-serving trustee, and thank goodness it doesn't happen too often, had the trust investments allocated in a completely improper way, and really was just administering the trust for his own benefit, in my opinion. And so these are the kinds of situations that are going to be overcome through proper trust management, proper fiduciary responsibility, and proper reliance on professionals. Okay, so I think we've said enough about this. And one of the last things here, this bullet point, is making sure the trustee understands the cash needs of the trust and keeps these cash allocations or availability of cash available to the beneficiary, and projects and uses the tools of the financial advisor to be able to understand how to make trusts last as long as possible. I will say that not every beneficiary is blessed with a very large trust that's going to take care of them forever. Most of the time, there are relatively finite assets, whether it's $500,000, $200,000, $5 million. Very rarely are we dealing with trusts that are bigger than that. but there are certainly trusts out there that are larger and don't have to have so many of these types of concerns. But generally speaking, we are dealing with a finite amount of money. We have to look at the beneficiary's age, their needs, and sometimes it takes a trustee that can talk very frankly, have straight talk with the beneficiary. As I did the other day, I had to speak to a beneficiary and be very honest and say, I'm your trustee, I have fiduciary responsibility, and we certainly cannot continue to drain the trust of the kind of distributions that you're requesting. It's not in your best interest. Even if we pass the trust along to a new trustee, I have a fiduciary duty not to throw the trust over to someone else if I wasn't serving, that is just going to write checks and deplete the trust, because that would be a breach of my fiduciary duty, in my opinion. So these collaborative arrangements with financial advisors, CPAs, and attorneys advising a trustee is really critical, and I think that should be part of your trustee selection. So speaking of trustee duties, I've asked Jeff to be thinking about if he runs across the pictures or photos of any perfect trustees. I've invited him to put those pictures on here. And so far, I don't think you've found anyone who's actually perfect, Jeff, but I know you're looking for them. And with all seriousness, these concentric circles, to me, illustrate what we're looking for in a trustee. So let's start with the bottom left. Accountability. So we want a trustee to keep accurate records. As you think through your trustee selection, I want you to look at these circles. This is going to guide you above and beyond anything today that I've discussed otherwise. Accurate records, keeps the beneficiaries informed, complies with statutory duties, and they're actually interested in complying, and that's important. They have to have an ability or a desire to be educated. I was very gratified in the last couple of months. I had a trustee who actually takes their responsibility so seriously. They came to consult with me, had me review the trust, and had me make sure that they're complying with all their duties. That was just an amazing thing, and that's what you're looking for. Financially, we want the trustee to make proper investments, but they don't have to do it themselves. They want to understand taxes, but they don't have to do it themselves. They want to hire professionals and understand they have the right to do so. Now, for certain beneficiaries, but generally for all beneficiaries, understand the best interests of the beneficiary, understand if they have public benefits such as disabilities and any kind of benefits, promote their independence. But beyond that, let's say we have a healthy beneficiary, the trustee needs to understand, keep them informed, understand their needs, understand and have a relationship with them. And I will go one step further, and Jeff, maybe in future presentations, will add this bullet point. The trustee should really have a relationship with the trust protector. And the trust protector is a special fiduciary that is not in all trusts for sure, but can be in a trust. And that special fiduciary, the trust protector, would have certain powers. And the trustee, in my opinion, and the trust protector need to be talking at least once a year to make sure that the trust protector understands what's happening with the trust and with the beneficiaries and the beneficiaries' lives. All right, Jeff, I'm going to stop just for a second to see if there's any questions right now. I don't think there are, but I'll just ask.
Thank you, Steve. We do have one, and see if you can speak to this regarding notice of requirements. What about notice requirement in DC and Virginia? Can you speak to that at all?
Oh, thank you for asking that. I apologize that I wouldn't be able to be intelligent about that right now because I'm not barred in either one of those jurisdictions. Maryland has adopted this Maryland Trust Act, which frankly, Maryland was behind on many of the national trust laws, and this really brought us up to date almost 10 years ago. I don't know what DC and Virginia's requirements are outside of probate. Certainly in probate, probate, it's estates, beneficiaries are entitled to notice. I believe I saw a Virginia trust some months ago that didn't require notice, and I'm not sure whether that's discretionary or whether that's just something that the law allows. So I apologize. I would have to research that offline. If you could send me a message, I can find that out.
Okay, thanks. We have a couple more if that's okay.
That's fine. Yes.
This is a good one we've never had before. What if they're just flying in here? I'm losing them. Okay, here it is. What if there is a conflict between one, the trust protector and corporate trustee, and a co-trustee and a corporate trustee?
Well, if I understand your question, the first part I think is straightforward. If a trust protector is given a general power to remove and replace trustees, then I think the corporate trustee is going to lose every time. The trust protector would have the power to change trustees. And, you know, one of the things I think about trust protectors is that they're not just this heavy-handed fiduciary, but you know, certainly they need to have limits, and their limits are in Maryland. They have to be acting as a fiduciary. But I think a trust protector can also be a mediator. So if there's a conflict between the corporate trustee and the trust protector, I think before the trust protector removes that entity, perhaps under those circumstances, there could be a mediation. Certainly no corporate fiduciary would want to lose a good trust. However, if the relationship with the beneficiary is difficult, perhaps the corporate fiduciary would say, no, we don't want to be involved in this trust. So I think it's going to be facts and circumstances there. And Jeff, what was the second part of the question?
Yes. What if there's a conflict between co-trustee and corporate trustee?
Yeah, so that's going to be a question of whether there is a trust protector at all, but it sounds like there might be in this trust. So I'd say if there's a conflict between co-trustee and corporate trustee, then it's going to depend on the terms and provisions of the trust. Does the trust have a trust protector that can mediate that dispute or remove beneficiaries and replace them? Probably remove the corporate trustee. I don't know for sure under those circumstances. And does the trust not have a trust protector, but it allows beneficiaries to remove trustees and so forth? So it's a question of really scrutinizing the document. But if a trust protector is involved, I have a feeling the trust protector is going to remove the corporate trustee, assuming the co-trustee is not the person who's really causing the problem per se, but who knows what those circumstances are.
Okay. Next question, can you have more than one trust? If a person has a home in Maryland and a home in another state, can one have trusts in both? Can one have one trust in both states?
Yes, thank you for that question. I think given a certain set of facts, that is absolutely possible. There would be no reason, for example, that you couldn't have a trust in another state. It may or may not make sense depending on whether that second property in that other state is a primary residence, like a second home or a residence, I should say. And if it were, then maybe it's not necessary to have two trusts for that particular situation. However, it may be a situation where the trust that you're talking about has nothing to do with a second property. Maybe it has to do with commercial property. Maybe there's a special reason why there should be a trust in a different state. So definitely states are in competition for trusts, states that have advanced trust laws. And that may or may not be the situation in the states that we're talking about there, but it certainly is conceivable that you could have two trusts, one in each state.
Okay, and a couple of questions about trust protectors, then we'll move on here. Can you elaborate on what that is and how do you find one and when it is important? So
that's a great question. So
maybe we should have a webinar on trust protectors, Steve.
Yes, trust protectors are an enigma to a lot of people, but to try to put clarity on it, Maryland has allowed in the law for trust protectors. Maryland actually calls it a trust advisor since 2014. Trust protectors have been around for some 20 years to 25 years. A trust protector is a flexibility mechanism. So let's say that there are millions of trusts out there and very few of them have trust protectors. But now if you create a trust or you have an old trust that could be amended, we can insert something called a trust protector. So we have a trustee who has the fiduciary duty of administering a trust, just like we talked about today. But then we can have a trust protector, which is a special fiduciary. And in my opinion, this special fiduciary's job is to further the intentions of the grantor. So the trust protector has the power of amendment. Now, in all fairness, we don't have a lot of time to talk about trust protectors. It takes a little bit of time to get your mind around this if you've never heard about a trust protector. A trust protector is a special fiduciary that has the power of amendment. They can amend a trust, let's say a revocable trust, as to its administrative provisions or its tax provisions. A good example would be a person has a revocable trust, but now the Secure Act comes along in 2020, a big law that changes how retirement plans are treated. So perhaps most revocable trusts would need to be updated by way of because of the Secure Act. But let's pretend that you could not update your trust for some reason. A trust protector would be able to amend that trust. A good example would be a special needs trust. That trust was established, the parents died, that trust is irrevocable, but now the Secure Act comes along. So the trust might need to be amended for purposes of IRAs and 401ks coming into that trust. So a trust protector can also remove and replace trustees. And for example, this morning I was reviewing a life insurance trust, which is an irrevocable trust. And the life insurance trust had many advanced trust protector powers beyond the basic power of amendment and beyond the basic power of removing and replacing trustees. So this is something that the grantor looks at and says, how much flexibility do I want? And do I feel good about this trust protector idea? And I'd say, in my opinion, you should install a trust protector to give flexibility to your trust down the road. But certainly there are circumstances, one more thing, Jeff, sorry. Certainly there are clients that are not going to be comfortable with the trust protector, and it's a case-by-case situation. But I'd say the vast majority of people today should install a trust protector provision.
Okay, thank you. Let's move on for now. Thank you.
All right, so trustee selection, as we start to get toward the latter part of the presentation now, why is it so important? Well, trust can last forever. We talked about that. Maryland says it. Delaware says it, most states say it. Trusts are more portable than ever. The nice person who just asked about whether trusts can be in different states. Here's an example that a trust is established, but now it needs to be changed to a new state. That can be done through flexibility drafting. States are in competition for trusts. I just mentioned that. There are states, for example, our neighbors in Delaware that have advanced trust laws. We are trying to catch up with them in some ways. Although Maryland has very good trust laws. Beneficiaries could change their domicile. A good example that I always like to use is when my kids, one of them moved to Colorado and back. A lot of people move to other states. We have to assume that our beneficiaries may end up living in another state. So trustee selection is important. Why is it also important? Trustees have options. They don't have to serve. I don't want to be discouraging, but we need to make sure that our trustees are willing to serve. What if we appoint someone who at the time of need, when we die or we're incapacitated, they refuse to serve? I've got two situations in mind very briefly. Remember, corporate fiduciaries can oftentimes refuse to serve. You have to install a trust protector to make sure that if that corporate trustee refuses to serve, that another one can be appointed. Or there could be a family member that you're relying on. I was called upon recently as a trust protector to notify people that the beneficiary was cognitively impaired and could not take care of himself. And when I contacted one of the fiduciaries, they said, we are not able to serve, we can't do it. So we just have to be aware that trustee selection is very important because people do not have to serve and we need flexibility. Decanting is the ability to actually change a trust from one form to a completely new form, not just to amend a trust, but to change it altogether. That's a shocker to some of you, but the decanting world does exist. Maryland has a new decanting law that's going to go into effect in October, but some of our surrounding states like Virginia and Delaware have very aggressive decanting laws. What does all that mean? It means that we need to have a trustee that understands your intentions. We need to have a trust protector that's furthering your intentions. And we want to make sure that a trust could not be changed unless it was absolutely needed. And sometimes decanting can be an amazing and powerful thing. We have to make sure that decanting could not be used in a negative way. And as I mentioned several times, we need flexibility for changing circumstances. All right, I appreciate your questions, and I'm going to keep moving. Jeff, if I can find my cursor here. Now, as we get towards the end, trustee selection for you might be easy. It might really be easy. There's a mental checklist you have, your children, your siblings, your other relatives. But we talked about independent trustees quite a bit. So let's talk about that really quickly. There are two types of independent trustees. Individual trustees, such as your friends or unrelated arm's length parties to your family, people who are not related. It could be your attorney, it could be your CPA, it could be even a financial advisor if the broker dealer allows it, but many times that is not allowed. But I have seen an increase in the ability of financial advisors to be able to act as fiduciaries, but not necessarily trustees, but as fiduciaries. So that's a case-by-case basis. And then, of course, we have corporate trustees, banks, trust companies. And these corporate entities have to post a schedule of fees with the Office of Financial Regulation. So some people are inclined to use corporate fiduciaries. When I was a young lawyer, there seemed to be a prevalent opinion that using corporate fiduciaries was really undesirable. And I never quite understood that, because I see a lot of our clients do prefer, in some cases, to have a corporate fiduciary involved, or have a co-trustee corporate fiduciary, or a successor trustee corporate fiduciary. What are the advantages? Well, they are seemingly objective, they are regulated, their fees are predictable, okay? They generally file the trust tax return every year, and they provide an accounting. So these are some of the things that I think are more advantageous for independent trustees. And there's an argument, as we try to be mindful of our time here, there is an argument about who should be, I'm digressing now, who should be a trust protector versus a trustee. So one way of thinking about it, depending on your family situation, is that perhaps an independent trustee should be the trustee versus family members, but that family members maybe should serve the role as trust protector. Now, this is not always the case. Sometimes there are at-risk beneficiaries, and that arrangement might be best. Family members being the trust protector or being the advocate. But in a traditional sense, the trust protector should be an independent person. So we kind of have this issue of who should be trustee, should they be interested or independent, and who should be the trust protector if we are including a trust protector. This is the fascinating thing about the design and your particular family situation, that what we want to do is work through this. There are no easy solutions many times, but to work through it, to diagram it, to think through it, and labor through it until we get to a point where we're happy. And then what? We have to make sure that we update the planning over the years. We've done the best we can. We've done the design that we can. We know that that plan is not forever. And this gets to this third bullet point that I'm really on right now. The discussion and document review and the visualization and so forth. We do the best we can in trustee selection, in trust design, in will design, and wills can have trusts, of course. But we are not locked in forever. Life is ever changing. And as long as we are committed to consistent updating every couple of years, especially as we get older, we can give ourselves permission to not worry about failure. We're not going to fail because we are diligent, we're thinking through the issues, and we're making the best choices that we can, and we are including flexibility measures. Trustee selection, we talked about conflicts between interested parties. I think that's pretty clear. We want to stay away from that most of the time. We talked about individual versus corporate independent trustees. We've talked about advantages and disadvantages. Let's talk about some disadvantages of the interested person. So the interested person is not a professional, and I think we've touched on most of these disadvantages. If the interested person is a person who insists on going it alone. I was called by another lawyer the other day to review a case that we have a trustee who is insisting on doing everything themselves. They are going it alone. They are not listening. They are not keeping the beneficiary informed and so forth. We just want to kind of know up front, are we dealing with an individual like that? And if we're not, then I think all possibilities are open. When we look at those concentric circles that I illustrated and we use that as our benchmark, we're going to be fine. But we don't want to set it and forget it. We want to do the best design we can, and we want to revise it and review it in the years to come. And we've talked about trust protector considerations. So independent, again, versus interested trustees, different points of view, different standards of distribution. It's beyond the scope of today's discussion, but you may recall that I said that where independent trustees are involved, we have theoretically much greater asset protection. That's because the standard of distribution can change, where we have an independent trustee to be more of a discretionary for any purpose standard of distribution versus the health, education, maintenance, and support ascertainable standard. So there's a reason why that that asset protection can either decrease or increase depending on that standard of distribution. Different levels of objectivity. We talked about many clients will see their corporate fiduciary as being more objective. That's a case-by-case basis. It does not apply to everyone. Different levels of oversight and different practical considerations that I think I've illustrated enough of those today. We talked about the trust protector. Thank you for asking that question early on. Let's look at this slide after today's presentation. Remember, this is a special fiduciary in Maryland. They must have fiduciary responsibility. It cannot be a non-fiduciary. I mentioned the background. They've been in Maryland since 2014. It's basically a power of amendment. The basic powers are appointment of and removal of trustees. They can direct the trustee, mediate disputes. They can review and compel accountings, and they can also administer, or amend a trust. And I should have put that on here, the power to amend. Oh, there it is, the fourth bullet point. And I promise we're getting to the end. Let's just discuss some practical roles. What is the role of a trustee in a will? Well, just because we have a will doesn't mean we can't leave a trust. So this could be a non-marital, or what we call a bypass trust at the death of one spouse, or a marital trust. Non-marital, marital, doesn't matter about those definitions today, but it's an irrevocable trust for a spouse. We need a trustee. That could be the spouse. It could be the spouse and others, such as children. It could be a spouse and a corporate trustee or an independent trustee. Trust for young beneficiaries. This is something that's included in most documents. If a beneficiary is under a certain age, they have a trust. The trustee of their own trust, we just talked about that. A trust that's created for life or for a certain period of time, and that beneficiary is the beneficiary of that irrevocable spendthrift trust, and or the trustee of another such trust for someone. These are the kinds of trusts that are established in wills. They're not the only kinds of trust, but these are just basic examples. The role of a trustee in a revocable living trust is somewhat different, but similar. Remember that the revocable trust is a basic form of a grantor trust, so it has to have a trustee during life, which is you, or you and your spouse. And upon the incapacity or death of you or your spouse or both of you, this is the same situation. We either have a non-marital or marital trust, same as a will, trust for young beneficiaries, same as a will, and the same types of irrevocable spendthrift trusts. Now, if you're a single person, right, there's not going to be a bypass or non-marital trust and a marital trust because you're not a married person. So it's simply not going to exist for certain of you who are not married. But what I'm trying to say here is under wills and trusts, whether it's these very basic trusts or whether there are other trusts that are created under a will or trust, the trustee has certain roles. And I'm just trying to give you a sense of that. And again, we talked about being redundant. The reasons to appoint a corporate trustee might be experience, management, they're regulated by state and federal government, their reliability, their objectivity, their referral ability to be able to advise beneficiaries, longevity, and peace of mind. Now, with that said, we are living in a world where we all know things are changing at the drop of, on a dime, so to speak. Things can change. Things that we valued today as permanent and seemingly very stable can change tomorrow. So all of these considerations for corporate or other trustees should be taken into consideration, also with the idea of we need flexibility in planning. I'm going to strongly encourage you to have documents that are modern, contemporary documents that include contemporary provisions such as a trust protector. Now, coming to the end of the presentation, and then we'll wrap up for any further questions. Why should we be concerned about this successor trustee risk? Well, for all the reasons I just mentioned, but age and experience of a trustee. I had a 105-year-old man in my conference room a year ago. And I've told that story many times because it's just amazing to me that this gentleman came and was talking about his estate planning. Now, what does that have to do with successor trustee risk? Well, people are living a long time. So just because someone is 65 or 70 years old or even 75 or older doesn't mean that they can't be good trustees. So I don't want to imply that, and I want to encourage you to appoint people who are qualified and not necessarily because of their age or youth. So age and experience, but no matter what though, is a risk. So we have to kind of look at that on a very objective basis. Health and their deterioration over time. Again, it doesn't mean that someone can't be a good trustee just because they're older, but we have to update and we have to maintain our plan. Many trusts do not require, most trusts do not require bonds. So when you create a trust, most trusts do not say, my trustee has to post a bond. Why is that? Because bonds are very expensive. They deplete the trust assets, so most people don't require them, but they are required in some cases. So this is a risk that over time, you're not really requiring a bond most of the time, and therefore, there is a possibility that a trustee could misuse the funds. So therefore, trust accountings, all of these kinds of oversights are important. Other life changes, divorce, creditors, bankruptcy, health issues like dementia, God forbid, the unforeseen, these kinds of things can cause us to have risk with our successor trustees. Disconnection with the beneficiary. This is a thing that I think everyone should be concerned about. And that's why I think the installation of a trust protector and having a trust protector and a trustee that are they're charged with having to stay in touch with one another over the years. I think this is a very important thing to make sure that beneficiaries are not disconnected or not taken care of. The demands of a beneficiary can actually be a risk. We can deal with a beneficiary that is so demanding, so difficult to deal with, that they actually can cause a trust to not function because it's difficult to find a trustee that's willing to take on the responsibility. So again, what does all this mean? It means we need flexibility in trust. We need the ability to be able to amend trust or to be able to appoint trustees as needed. And you need to take great care in the design so that you're appointing your primary trustees, your successor trustees, with full consideration of all types of the trustee characteristics. The trustee's willingness, fortitude, and perseverance. This is what I was referring to earlier. Trustees need to be willing to serve, willing to have, and they must have the characteristics to be able to withstand dealing with a difficult beneficiary. And hopefully your situation is one where there is not a difficult beneficiary. And then trustee compensation. Compensation is going to depend on the document that you create. A modern trend is to use the standard of reasonable compensation. Certain trusts are governed under Maryland law, statutory compensation because of the way they were written. And then I said that independent trustees have posted their fiduciary compensation schedules with the Office of Financial Regulation, and you need to understand what those are. But that is a risk, meaning that we want to make sure that our trustee is being compensated appropriately so they're willing to serve, but also we want to make sure that they're not depleting the trust with their compensation and other risks. So a path forward as we wrap up, and I thank you for your time and attention in this long webinar and wonderful questions. I just want to encourage you to feel that resources are available to you. Jeff is here to help you set an appointment if you would like to review something with me or another associate at Elville Associates. There's nothing to fear in this process because when you ask for us to review documents, we generally do not charge for most document reviews. But the reason there's nothing to fear is because when you consult with someone who is an attorney in Maryland, there is an attorney-client relationship. Even if you don't move forward with that attorney, there is a confidential attorney-client relationship just with regard to the discussion. So there's nothing to fear there. We encourage you to bring the current documents or to come in and talk about the design of new documents. And we want you to have a financial advisor and a CPA and an insurance professional, whatever it is that we can help you form to have a collaborative planning team. And we have some very strong feelings about how we want those collaborative partners to be communicating with one another for your benefit. So we're willing and happy to help you form an advisory team if you need one. We also like to answer questions. If you come prepared with a list of questions, we welcome that. And also we want to give you the time to think. Our conference rooms are equipped with high-tech equipment. We have several large conference rooms. We're here to help you think through issues. And we know that some of you don't know the right questions to ask, but we want to help you develop those. Some of you don't know the right path to take, but we want to help you have that epiphany by giving you the time to think in this very busy world. So with that said, Jeff, I'm going to turn it back to you. And I just think it was just a wonderful session with great questions. And I thank everyone. And I wish you a happy holiday weekend ahead.
Well, thank you as always, Steve. Great information, very important topic, as we always say, and working hard to bring some clarity to it. And working to bring clarity sometimes brings additional questions, and that's what I have for you right now. Okay. So let's go ahead and try to work on some of these questions, and then we'll go ahead and wrap up right around being on time here. First question, can a Maryland trust, from one of our financial advisor friends here, can a Maryland trust have a trustee from a different state? Also, can beneficiaries be in different states from a trust and or trustee?
Thank you for that question. The answer is yes to both. I see no reason why a Maryland trust couldn't have an out-of-state trustee, and then a trust can have beneficiaries in various states. Yes.
Okay. Next question, can a trust be designated to be spent in the lifetime of a beneficiary?
Jeff, did you say can a trust be designated to have to be spent during the lifetime of a beneficiary?
Exactly, yes.
The answer, I guess, is I guess any trust can have a provision that says that. Now, the question in my mind is whether it is effective, whether it's going to be legally effective. So I think that through a letter of wishes and through the provisions of the trust itself, a grantor could express that they want the trust to be distributed liberally, even to the extent of exhaustion. And that's sometimes a rather common provision. So I think this particular case, you'd have to go further than that and say, it being my specific intentions to that the trust principal be depleted in its entirety during the beneficiary's lifetime. Now, again, I think that is more of an aspirational thing rather than a legal mandate, because maybe the trustee has lots of reasons why they would say, hey, I couldn't do that, or I didn't have anything reasonable that I could spend the money on without worrying about breaching my own fiduciary duty. But clearly with those kinds of instructions, I think you would be giving the trustee legal cover, so to speak, to be able to expend the trust liberally. But I think you would want to very much outline in a letter of wishes what you mean by that and what types of things you would want the money to be spent on.
Okay. Next, can a foreign national serve as trustee for a Maryland trust for a minor?
Thank you for that question. I think that based on the facts and circumstances of this particular situation, the answer probably would be no, because the foreign national would not be subject to the jurisdiction of a U.S. court. So I think that would be a problem. And I think the answer would be no there, but I'd have to research your particular situation.
Okay. Thank you for this education. There is a tendency to just name family members who you know and love as successor trustees, of course, without knowing how complicated and involved trustee duties and responsibilities become. Thank you so much. Can you speak briefly to this?
Thank you. Thank you so much for your kind words. I think that's true, everything you just said. And nothing here is meant to say that that's not the right path. As I said there towards the end, you might have a mental checklist already, but I think the key there is where it seems, on one hand, we have the legal side, and on the other hand, we have the emotional and personal side on your side. And I think if your gut feeling tells you my children should be trustees and my family members, I think that's what you go with. No matter what a lawyer says, you're going to have an emotional a relationship with your own planning. And I think if you decide to stay the course with family member trustee fiduciaries, then I think the answer there is family education, which is what our client care program is designed to do, but also as part of planning to have a family meeting where the fiduciaries, your future trustee children, are brought into the planning process and they understand what their duties are and they can be educated. So I think lifetime education for them is going to overcome some of these problems where you're staying the course with family member trustees.
Okay. Are there cautions about having an individual, for example, an attorney, as both a trustee and general power of attorney?
Oh, that's a great question. I think the caution there is you're appointing a non-family member as a fiduciary, like your agent under a power of attorney and the successor trustee to you. And I think as long as the proper safeguards are in there, I think you're fine. Remember the concept that a trust protector is important. So if you put a trust protector in the trust, someone who's truly independent, and they would remove that attorney if that attorney needed to be removed, then I think you're fine there. With regard to the financial power of attorney, remember the only way to control, so to speak, the behavior of someone is to use co-trustees, in your example, co-agents in that financial power of attorney. So you can control the behavior of a single fiduciary by co-agents or co-trustees. And also in the trust, you can control by way of the same thing, but also by use of a trust protector.
Okay. Next one, if a corporate trustee is a bank and the bank fails, are the funds in the trust protected?
That is a wonderful question. I think in light of all the recent events where we didn't think future bank failures were possible, and we are seeing that is possible, I think my top of the head response, this is not a really well thought out answer because I don't have a good answer, would be that the trust funds, I think, are as safe as the bank funds. So whatever the safety is that would apply to the bank funds, I would assume would apply to the trust funds held at the bank. But that would have to, I think, be answered by the specific bank, and we'd have to look at that situation. But I think part of the trustee's fiduciary duty would be to make sure that the funds are invested at a bank where that kind of thing is not likely to happen. Now, the trustee will have no responsibility for the loss of those funds so long as that trustee was prudent. They acted as a prudent person would, and they did not engage in any kind of negligence. But that's a wonderful question that I think we'd have to answer based on the specific bank.
What can be done if a trustee refuses to provide a copy of trust and annual reports?
That's a great question. I think that depending on what the structure of that trust is, if there's a trust protector, I would get the trust protector involved to probably mediate this or remove the trustee. But if there is no trust protector, which many trusts do not have a trust protector, then I think if you are a beneficiary and that person, that trustee is not providing that information to you, I think your redress is to make a demand on that trustee. And if you've already made a demand and they are not following through with what their responsibilities are, then you would have to petition a circuit court to be able to say this trustee has not met the requirements of Maryland law and they should be removed. But first and foremost, they should have to provide what I'm asking for.
Okay, and last question. Can a trustee be a non-US citizen / US resident / PR as it relates to taxation?
Well, this is, I think, a pretty complex question that I would have to look at individually with you. The person who is a non-US resident, excuse me, a non-US citizen, but is a resident, I think they can serve. My initial reaction is they can serve as long as a US court has jurisdiction over them. I don't think they would be disqualified, but I'd have to read the rules on that one. So if you would mind, please email me that factual situation and we could try to provide an answer for you on that one.
Okay. Okay, lots of great questions. Thank you so much. Steve, great job. Thank you for being such a great resource. And if we can be of any service or help to you here at Elville & Associates, always don't hesitate to give us a call or email Steve or me, and we'll be happy to help. I can always set times for you to meet with Steve. Always glad to do it, and that's what we're here for. Looks like we have no more questions. We hope to see you on our special needs planning webinar next Friday at 10 o'clock. That's our next Elville webinar series presentation. And hope you have a great holiday weekend. Remember the true purpose of this weekend, which is to honor the men and women who've made the ultimate sacrifice while serving our country in the military. So remember that while we're all enjoying ourselves as well. And hope you all do have a great weekend. And we'll see you soon back on the Elville webinar series. Have a great weekend, everybody. Take care.